Hello and welcome to our lunchtime webinar. We'll be giving you some practical help and support in moving towards outcomes-focused regulation. This session is aimed particularly at small firms. Throughout our presentation, we'll be using the shorthand reference OFR to mean outcomes-focused regulation, because it's a bit of a mouthful. Thanks for joining us, and we hope you enjoy the session and that you find it helpful. My name's Nikki Taylor, and I'm a member of the SRA's team, which has drafted the new SRA Handbook. I've worked on the various consultations and the policy development which have led up to our new handbook. I'm a solicitor with experience in working in small high street firms. I've had extensive experience of legal regulation, having worked for the Law Society and now the SRA for many years, including working in policy development, supervision and enforcement. I have today with me Helen Venn. She'll introduce herself now and give you an overview of our session. Over to you, Helen.
Thank you, Nikki, and good afternoon all. My name is Helen Venn. I qualified as a solicitor over 15 years ago in a medium-sized practice in Birmingham, which specialised in criminal law. I've worked at the Criminal Cases Review Commission and the Serious Fraud Office, and have been in legal regulation for the last 8 years. Let's start by looking at the format of this webinar. We'll start by giving this presentation, which will last in the region of 40 minutes. You can download the slides from our website, so there's no need for detailed note-taking. And you can hear this presentation again and hear our webinars on other topics by visiting our website. At the end of our presentation, as already mentioned, we welcome your questions and comments, and these can be made by email or over the phone. We are interested in hearing your views on certain topics, and we'll be inviting you to take part in a mini poll during the webinar. Now, a brief word about CPD. For those registered with us for this live webinar, 1 hour CPD can be claimed, and we will give you the details of the CPD code at the end of the webinar. And now back to you, Nikki.
Thanks, Helen. Right, now our next slide shows a summary of our talk today. Today we'll be talking about outcomes-focused regulation generally, the new SRA Handbook, risk assessment and risk management, and our approach to the supervision of firms with a focus on small firms. So first, Helen will explain what OFR is, and maybe more importantly, what it is not, and how the SRA is getting ready to deliver OFR. Next, I'll be giving you an overview of the SRA's handbook, with a special focus on the 10 principles which underpin the whole structure. We'll look at a couple of examples of how the new Code of Conduct works. The code is part of the handbook, and how it applies our OFR approach. Helen will then explain about the management of risks, how firms will need to do this, and how the SRA will assess risk. Then we'll look at the 2 new key roles, the COLP and the COFA. These are the compliance officers which all firms, including sole practitioners, will need to think about filling. Next, we'll review the key steps firms will need to take and the help that's available from us to support you. Over to you now, Helen, for a bit of background on OFR.
Thank you. The Legal Services Act 2007 brings about significant changes to the regulatory framework for us and for firms. The regulatory regime focuses on high-level principles and outcomes that should drive the provision of services for clients and the wider public interest. These changes offer new opportunities for current firms and different, more flexible structures for existing firms and new entrants. It includes the opportunities brought about by alternative business structures, commonly known as ABSs. But changes driven by us, the SRA, We recognise that in the past our regulation may have been weighted on the application of detailed rules, taking action against breaches of these rules. Under OFR, we are moving to place greater emphasis on working with firms to ensure they are complying with the principles and achieving the right outcomes for clients and the general public interest. Where firms are capable and willing to comply with the principles to achieve the right outcomes, we will work with them to do so, saving enforcement action for those who are incapable or unwilling. So let's take a look at what OFR isn't. And on this slide it lists those points. OFR is not light touch regulation. It is not a tick box approach nor a one-size-fits-all approach to regulation, and neither is OFR a dilution of our professional principles. What OFR is a move away from prescriptive rules to give firms more flexibility in delivering outcomes for their clients in a way that suits your clients' needs. It allows you as firms to take greater responsibility for compliance, and it allows us and you to tackle regulatory issues rather than a tick box compliance. Now, to support OFR, the SRA is undergoing radical change. As I mentioned earlier, we, the SRA, recognised that change within our organisation was necessary, and we are currently undergoing an extensive restructure to reflect our key functions. We are committed to providing an efficient and effective service, and we are training our people to ensure that we are ready to implement OFR. Firms will not pay a separate OFR levy. We expect cost to firms will decrease as firms will be able to show compliance in ways best suited to your clients and your business. And this will remove the burden of firms having to show compliance in unnecessarily detailed, prescriptive or less relevant areas, ensuring time and resources are focused on important areas. So the SRA's three core functions will be authorisation, supervision and enforcement, and our risk centre will cut across these three areas, indeed across the organisation. Authorisation is the gateway to practice, the stage at which we first assess risk and suitability. And there's an SRA webinar about the authorisation function on the 28th of June, so please join us if you can for that. Supervision is the function that will have oversight of all our regulated firms, and I'll talk about this in more detail later. There has been a supervision webinar, and again details of this are on our website. But when serious problems do arise, or where firms will not cooperate with us, we will take tough enforcement action to create both a deterrent to others and to protect the public interest. And now I'll hand back to Nikki, who will talk about the new SRA Handbook.
Thanks, Helen. Okay, so this slide shows us the structure of the new handbook, and we're going to take a look at the navigation and what that structure, and dig down through the structure a little bit. So, the new SRA Handbook brings together in one place all the regulatory requirements that apply to everyone we regulate, including sole practices, traditional firms, in-house practice, and the new ABSs. Our intention is that clients of all types of legal practice receive the same level of protection. The Legal Services Board, which is our overarching regulator, has recently approved our handbook. We expect it to come into force on the 6th of October this year. Please visit our website and start to become familiar with our new handbook. Okay, so let's take a look at the individual elements of the handbook. First of all, there are the 10 SRA principles, and these are absolutely fundamental to the handbook and to OFR, and we'll be looking at these 10 principles in a little more detail shortly. Next we have the SRA Code of Conduct. This is very different from the current 2007 code. Rather than containing prescriptive rules and supported by guidance, it contains mandatory outcomes and non-mandatory indicative behaviours. Now let's have a little word about both the outcomes and the indicative behaviours. Outcomes describe what you are expected to achieve in order to comply with the principles in specific contexts. The indicative behaviours are examples of the kind of behaviours which may establish whether you've achieved the outcomes and complied with the principles. The code provides clarity for consumers about the outcomes and the protections they can expect. Okay, so the next section of the handbook is the accounts rules section. Now these will be, I think, fairly familiar. These are the rules for the protection of client money. They include new outcomes-focused provisions, however, on authorising withdrawals from client accounts and accounting to clients for interest. So they therefore provide some operational flexibility. The next section of the handbook is the authorisation and practicing requirements section. And this section sets out our new approach to authorisation of firms, including sole practitioners and ABSs, appointing compliance officers, this is the Kolp and Coffer, and more on those roles later, notification requirements, admission and education and training requirements. Moving on then to the next section, this is about client protection, and it contains new outcomes and rules concerning professional indemnity insurance and the compensation fund. Our next section looks at discipline and cost recovery, and it sets out our new approach to fining and disciplining firms and individuals. Next we have the specialist services section, and this contains provisions for firms which offer financial services and property selling to clients, and provisions containing European cross-border activities. And then finally we have the glossary. Now this is something which is new. The glossary will be the one single source of definitions for the terms used throughout the handbook. It's still being refined, and for the time being, each set of rules which comprise the handbook contain its own definitions. Now, let's have a closer look at the 10 principles which we've just mentioned. So, the 10 SRA principles, as I said, lie at the heart of our new structure. We expect you to act in accordance with the principles in everything you do. You need to use them as the basis for decision making. The first 6 principles will be very familiar to you. So let's look at principle 1. You must uphold the rule of law and the proper administration of justice. So this principle recognises that you have obligations not only to your clients, but also to the court and third parties with whom you have dealings on your client's behalf. And take a look at chapters 5 and 11 of the new code for some more details. Principle 2 says you must act with integrity. Now, personal integrity is central to your role as your client's trusted advisor and must characterise all your dealings with both clients and third parties. Then Principle 3 says you must not allow your independence to be compromised. By independence, we mean not only your own and your firm's independence. You obviously must be able to give independent advice to clients, but what is terribly important is that you and your firm remain independent, and you must not put your independence at risk by giving control of your practice to an unregulated third party. Now, Principle 4 says you must act in the best interests of each client. you should always act in good faith and do your best for each client. In particular, you must observe your duty of confidentiality and have regard to your obligations regarding conflicts of interest. And you can see more detail about conflicts and confidentiality in chapters 4 and 3 of the Code of Conduct. Now, let's look at Principle 5. Principle 5 says you must provide a proper standard of service for your clients. So you should, for example, provide a proper standard of client care and take into account each client's particular circumstances. Principle 6 requires you to behave in a way that maintains the trust the public places in you and the provision of legal services. So any behaviour, either within or outside your professional practice, which undermines public trust, damages not only your reputation, but also the ability of the legal profession as a whole to serve society. So those are the first 6 principles. Now let's take a look at the 4 so-called new principles. You'll see that although the values which principles 7 to 10 express are not expressed exactly as principles in the current 2007 Code of Conduct, they are all central to the delivery of OFR and client protection. So the content of these so-called new principles will be very familiar to you. So let's look at Principle 7. You must comply with your legal and regulatory obligations and deal with your regulators and ombudsman in an open, timely and cooperative manner. You should, for example, comply with the reporting and notification requirements and respond fully to communications from us. We need information about a firm in order to assess risk. Risk is a central plank of OFR, and Helen will be talking to you a little bit more about this later. Now let's look at Principle 8, which says you must run your business or carry out your role in the business effectively and in accordance with proper governance and sound financial and risk management principles. Whether you're a manager or an employee, you have a role to play in helping to ensure that your business is run for the benefit of clients. For example, meeting the outcomes in Chapter 7 of the Code, which is about management of your business. This again supports OFR and the assessment by firms of risk. Moving on now to Principle number 9, this says that you must run your business or carry out your role in the business in a way that encourages equality of opportunity and respect for diversity. So again, whether you're a manager or an employee, you have a role to play in achieving the outcomes in Chapter 2 of the Code, which is about your clients and equality and diversity. And then finally we come on to Principle 10, which is that you must protect client money and assets. This principle goes to the very heart of acting in the best interests of your clients, and you must play your part in protecting property belonging to your clients. Now, a quick word about enforcement for breaches of the principles. Our approach to enforcement is proportionate and outcomes focused and risk-based. Therefore, how we deal with any failure to comply with the principles will depend on all the circumstances. Our aim will be to secure the right outcomes for clients and to protect the wider public interest. Okay, now, we'll take a short break for a question. We really value your feedback, and we're keen to help firms, particularly small firms whose resources may be limited, understand and get ready for OFR and our new handbook. We're providing information on our website, and we're keen to get a feel as to whether you find it helpful. A key document on the website is called Outcomes Focused Regulation at a Glance, OFR at a Glance, your quick guide to getting started with OFR and the new handbook. Now, we'd be grateful if you'd let us know by voting yes or no whether you do find it helpful. If you haven't yet managed to look at it, we do recommend that you do so as soon as you can and draw it to the attention of others in your firms. So, please could you vote now? Oh, that looks very, very, very encouraging and promising, and we have many people have looked at it. Helen.
I was just going to say, currently over 90% have looked at the website and at OFR at a glance. As Nick has already said, would encourage anyone who hasn't looked to look at that guide. It's very useful, but that's an encouraging response.
Yes, that's looking very, very good. Yes, and I think they find it very helpful. I think, yes, excellent. Good. Well, thank you for that. And as we said, please spread the word amongst your colleagues. So now we'll have a look at the OFR mindset. So this is a shift to a different way of thinking. And I want to look at a couple of examples from the new code in the handbook, which will show you what's different about the OFR approach. It's important to remember that responsibility for meeting requirements in the handbook and for operating effective systems and processes within a practice lies with you. You'll see we've stripped out of the new code much of the detail which is currently in the 2007 code. And this is to empower you to implement the right systems and controls for your clients and for your type of practice. You have more flexibility and can use your judgment. You do need to get used to a different way of thinking, just as we need to do at the SRA. So here are some examples of our new approach to help you get into the OFR mindset. Okay, on the slide you'll see that we have some details about reporting requirements, contrasting the old and the new approach. So instead of having reporting requirements on limited areas, Principle 7, which was just looked at, requires you to cooperate more generally with regulators. And you'll find other notification and information requirements in the authorization rules, practice framework rules, practicing regulations, and the code of conduct and the accounts rules. So let's look at another example, client care. The current rules, that's the 2007 code, set out a prescriptive list of the type of information which you must give to clients. Now, this contrasts with the new handbook in Chapter 1 of the Code of Conduct. The outcomes include that clients are in a position to make informed decisions about their matter. And the indicative behaviours, which we mentioned earlier, give examples of how you might achieve this outcome. But it's for you to decide what's appropriate for your client, taking into account any vulnerability or indeed how sophisticated they might be. And another example to help get us used to the new OFR mindset is around managing your business. The current rules in the 2007 code again set out detailed requirements. Now this contrasts with the new code, which is in the handbook. Business management has been elevated to a principle. The outcomes in the relevant chapter focus on the need for firms to identify risks and operate effective systems and controls to mitigate those risks. Now, risk. We're going to hand over to Helen now to explain a little bit more about risk. Over to you, Helen.
Thank you, Nikki. And before I start talking about risk, I would like to start by saying that it's important to remember firms that are already well managed and providing a good service to clients should have nothing to fear from the outcomes-focused regulatory approach. We will be encouraging firms to identify, manage and mitigate any risks to your ability to meet the requirements of the handbook. We will expect you to be forward-looking and also able to identify emerging risks. So, for example, have you thought about succession planning? And it might be that the vast majority of firms are already thinking in this way. When thinking about your firm's compliance with the handbook, look at Section 5 of Outcomes-Focused Regulation at a glance, and this lists a series of questions that you might want to ask yourself when considering whether you have effective compliance arrangements in place. So, for example, does the type of what you do pose particular risks to meeting the handbook requirements? In identifying and managing risk, it is for you to decide on the form that your systems and controls take. Consider how you identify, manage and mitigate any risks. You can then look to ensure that your systems, controls and policies are effective. So, for example, are risk and compliance issues regularly monitored? Staying with the theme of risk, the next slide asks, what do we mean by risk? And we refer throughout the webinar to the SRA website, which has a whole host of useful information, and there's a very useful section on the risk framework. Because when we're talking about risk, we are talking about risk to our regulatory objectives. Our approach to risk is twofold. It will take account of probability factors, so the likelihood of something going wrong or not being achieved, and also the impact of any such event. Therefore, if a firm is assessed as high impact or high risk, we may not actually have any concerns about the operation of that firm. But if that firm were to behave poorly, it would have a high impact on our ability to achieve our regulatory objectives. So the important point is that high risk or high impact does not mean that the firm is operating poorly, and I'll emphasise again, what it does mean is that firm, if they behave poorly, would have a high impact upon the SRA's ability to achieve our regulatory objectives. So our starting point will be our risk centre, who will initially allocate an impact banding to firms. One of the big factors of the impact banding will be size, and the bands will be high, medium or low. And depending which impact banding a firm falls into, will inform the amount of supervisory resource which we allocate. And the higher impact or higher risk firms will attract more of our resource than lower risk impact firms. The high impact risk firms will have a named contact, a relationship manager, who will work closely with the firm, but the number of firms in this category will be small. And again, I'll repeat the message that high impact does not mean a poorly operating firm. However, the majority of firms will fall within medium and low impact bandings, and small firms are likely to fall within the low impact stroke risk category. And for these firms, there will be teams of supervisors working with firms across those impact bandings, but there will not be a named contact. Engagement for firms in the medium and low impact bandings will be desk-based or visits if appropriate, but in the vast majority of cases we will be telephoning firms in the first instance. And the emphasis is on constructive engagement, and by that I mean a meaningful dialogue. It's important to emphasise that supervision is not about catching firms out for minor breaches of regulations. So a small firm within the low impact category is likely to experience what we might term as low intensity supervision, and that means that we, the SRA, will only contact the firm as required. This might, for example, be as part of a piece of themed work, perhaps around the area of conveyancing. Now, if a firm does get into difficulties but shows a willingness and capability to put things right, we will look to use supervision resource to support and monitor the firm to do a better job, rather than approach the matter with a disciplinary mindset. Our point of contact with the firm going forward will be via the Culp and Coffer. And just before we talk about those Culp and Coffer roles, the compliance officer roles, let's give an example of what I've been talking about in relation to risk and supervision. So let's say we as the SRA receive a number of complaints about a firm that had not previously come to our attention in respect of complaints from consumers. We look at the content of the complaints and it's apparent that they relate only to a particular part of the practice and that otherwise the firm seems to be delivering good legal services to consumers. What would we do in these circumstances? Well, initially we would make contact with the firm and that would be by telephone to discuss these issues. And through this form of desk-based supervision, there would be a short period of review for the firm to address the issues and bring the service delivery up to the same standard as the rest of the firm. And we could provide support throughout this process. We would then undertake a review of that area of the firm's business at a later date to ensure that the firm is still addressing the issues and the issue has been resolved. I'll now hand over to Nikki, who's going to talk in more detail about the compliance roles which we use the shorthand Culp and Coffer for.
Thanks, Helen. So, our next slide has details of the Culp and the Coffer. You've heard quite a bit about these already, but let's look at them in a little more detail. So the SRA authorization rules contain requirements that all firms which we authorize will need to appoint compliance officers for illegal practice and for finance and administration, the Culp and the Coffer. Risk management and proper governance of firms for the ultimate protection of clients is at the heart of these roles. And for a quick summary of the roles, please have a look at OSR at a glance, which you've heard about before. We'll be running a webinar devoted to the roles of Culps and Coffers on 7th July, so please join us if you can. Briefly, the compliance officers, who can be employees but must have sufficient authority for their roles, ensure that the firm complies with regulatory requirements, record failure to do so, and report to the SRA material failures. So, you'll need to decide who you're going to appoint as a Culp and a Coffer. And remember, this can be the same person and may well be in a small firm. How will the Culp and Coffer operate within your particular business structure? What systems are needed to support these roles? Do you need to change your governance and reporting lines to ensure that the Culp or Coffer is suitably empowered? But one really important point to remember is this: ultimate responsibility for compliance rests, as always, with the firm's managers. Now, a word about timing. Back to you, Helen.
So the timings to nominate and approve Culps and Coffers: if you're an existing recognised body, including a sole practitioner, as these will become recognised bodies on the 31st of March 2012, that's next year, and are not planning to convert to be an ABS, you will need to nominate your Culp and Coffer for approval by the 31st of March 2012, and they will be authorised from the 31st of October 2012. New recognised bodies will apply as from 28th of February 2012 under the new authorisation rules, and will need to nominate a Culp and Coffer for approval as part of the authorisation process. Again, the Culp and Coffer will be authorised as from 31st of October 2012. All LDPs with non-lawyer managers are ABSs, and they have a grace period, but will need to become licensed as such by 31st of October 2012 at the latest. This will be dealt with by the SRA as a passporting exercise. However, such firms could elect to be passported at any time from the 6th of October this year. they will need to apply for approval of their designated COLP and COFR, which can be done from 10th of August this year. So for firms wanting to take advantage of the grace period, they will be asked to designate COLPs and COFRs by the 31st of March 2012. New ABSs will have to nominate a COLP and COFR for approval as part of the authorisation process, and they will take up their responsibilities at the point when the firm is authorised. And you'll see from the slide that the timeline is subject to a parliamentary timetable. Now let's move on to see how we can get ready for OFR. So getting ready for OFR, begin by looking at the SRA website and the outcomes-focused regulation at a glance, which we are encouraged to hear from the polling question that the vast majority of you have looked at and found helpful. It's a very practical guide, as you'll be aware. You will also find on the website the new handbook, and there are examples and comparisons of old and new approaches and practical suggestions to help you plan for change. The OFR at a glance document contains lots of information, as you're probably aware, about COLPs and COFRs, also useful question and answer sections covering topics such as client care, referrals and complaints handling. And staying with the SRA website, have a look at the new handbook online and start to become familiar with the new code, the principles and the mandatory outcomes. Think about your firm and work through the questions listed in the effective compliance section of OFR at a glance, and that's at section 5.1. And please remember, as I've already said, firms that are already well managed and providing a good service to clients, you should have nothing to fear from the outcomes-focused regulatory approach. Now, moving on to tools that will help you. We've already mentioned a number of times now OFR at a glance and the online handbook. We have mentioned, but I'll refer again to a number of SRA webinars coming up, and these cover topics such as authorisation. I think Nikki has already mentioned that there's an authorisation webinar due to be held on the 28th of June. We've also been doing a number of SRA roadshows up and down the country talking about OFR, the new approach, the new handbook and the new functions. If you haven't managed to make it to one of our roadshows, there is a webinar roadshow on the 30th of June, so please do join us for that if you can. There is also a webinar on the 7th of July, which is solely relating to the topic of COLPs and COFRs, so that's certainly a very useful webinar to join. But do have a look at the SRA website. It has a full list of webinars, including previous webinar recordings that you can listen to. Carrying on with the list of tools to help you, the SRA Ethics Helpline continues, and we're also introducing My SRA, and this is to replace paper-based system of application forms and fees. In the very near future, you will be provided with a unique username and password so that you can access your own SRA online account. And now I think we'd like to move to a second polling question. This question relates to the supervision function, which, as I've mentioned, will have oversight of all regulated firms. There are currently 2 live pilots being run, one working with low and medium risk or impact firms, the supervision pilot, and one working with a variety of sizes of firm, including city and global firms, and that's the relationship management pilot. The polling question asks, have you looked on our website for information about supervision, particularly the relationship management and supervision pilots? We'd be grateful if you would vote. In fact, many of you have voted, and the vast majority, at present over 90%, have not looked at the website in relation to those pilots in the supervision function. If you haven't, we would strongly recommend that you do so, because there's a lot of useful information about the supervisory function, and if you have contact with the SRA, it's likely to be via that supervision function. So please do look at the information about supervision and the relationship management pilots. So thank you for joining in with that second polling question. And now back to Nikki.
Thanks, Helen. All right. The next section will be over to you for questions, but before we get started on that section, I'd just like to mention that we'll be giving details of the CPD reference after the question session. Now, if you'd like to ask us a question on the telephone and have not already dialed in using your keypad, please see the instructions on the slide. Okay then, we're happy to answer any questions or receive any comments, and you can send these through to us by email or, as I've mentioned, by phone. Over to you now. Right, we have a first question here. Now somebody's asking, won't risk-based regulation expose smaller firms to heavier supervision? Helen, do you think you could please tell us about that?
Certainly, Nikki. Let me answer that question. The very short answer is no, it won't. As I've mentioned, the degree of supervision will be proportionate to the level of risk. So OFR helps ensure more proportionate regulation than before. So firms will be facing supervision proportionate to the level of risk they present, and if firms produce the right outcomes, they will face a lesser burden regardless of their size. And firms will be able to show compliance in ways which best suit their business and their clients, and this is likely to vary depending upon the size of the business. But all firms will have to show that they give a good quality of service to their clients. This is the minimum we'd expect from any firm, small or large. Just on the issue of compliance, a question has come in about how compliance can be evidenced, and I'll answer that, Nikki, if I may.
Sure. Go ahead, Helen.
Firstly, if we say how firms evidence compliance is a matter for individual firms, and that's one of the advantages of OFR, that it gives flexibility to firms and that they can choose a method for achieving outcomes which best suits your own clients' needs and your business model. I think perhaps it's always useful to look at an example. Perhaps if we look at the area of client relations, say, to give some ideas about evidencing compliance, but these are just ideas and you must do what is best for your firm. But you could, in the area of client relations, look at results of internal monitoring, the firm's own risk assessment, perhaps client satisfaction surveys, maybe you'd look at analysis of client complaints, any claims, internal file audits, perhaps training, outcomes of periodic reviews of documentation. So there are lots of different kinds of things that you could do to evidence compliance. But again, flexibility is the key, and it's for the firms to choose the best way for you to evidence compliance.
Thanks, Helen. Right, well, we've received several questions on the subject of culps and coffers. We have one that asks, how do sole practitioners deal with the culp and coffer requirements? The culp and coffer can be, as we've mentioned, an employee in the firm, or it could be the sole practitioner themselves. It really all depends on the sole practitioner's particular business model. This is really where flexibility comes into OFR. And indeed, the culp and coffer can be one and the same person. But I would encourage you to have a look at getting started for OFR, the guide, and again to attend the webinar on culp and coffer if you can. Another question on Culp and Coffer is, can the roles be outsourced? Well, no, they can't. It's absolutely essential that the Culp and Coffer function is part of the practice. So we don't view this as being an appropriate role for being outsourced. Another question, carrying on with this theme, does the appointment of Culps and Coffers apply to in-house legal practice in public authority context? Well, no, it doesn't. The requirement to have a Culp and a Coffer only applies to firms. It does not apply to in-house practice.
And I think we would like to reiterate a point that Nikki made earlier, in that the ultimate responsibility for compliance rests with the firm, not with the Culp and Coffer.
The Culp and Coffer is very much there to ensure that the systems are in place, but ultimate responsibility rests, as it always does, with the principals and the firms.
I've got a short question here, Nikki, about the handbook, asking, will the handbook be available in hard copy? And the answer to that is yes.
I believe it will be. I understand that the Law Society will be producing a hard copy of the handbook. I can't tell you exactly what the time scale is for that, but in the meantime, the handbook is available on the website, and actually the website is really your best bet because you can be sure that the online version will be kept up to date. So please become familiar with it on the SRA's website.
Certainly, because it's got a very good search function, and also it's possible to PDF sections and print those off. So
perhaps when the glossary, which I mentioned at the beginning, is up and running, we are putting quite a lot of effort into designing a way of so that you can hover the mouse over the defined term, and then we expect that the definition to pop up. So we're trying to make this as user friendly as we possibly can. Helen.
Nikki, I've got quite a few questions that have come in about risk. First of all, will a firm know what banding they're in?
Mm-hmm.
Again, talking about the SRA website, I would urge you to look at the risk section, which is comprehensive and begins by saying how firm risk will be assessed. And that will, in the first cut, be by size, potential vulnerability of clients, and the amount of client money it may hold. But size will be a very large determinative factor. So it's the larger firms that will fall into the high impact category. I already mentioned, but let me repeat, that for the majority of small firms, they will fall at the other end of the scale in the low impact risk category. Now, as a transparent regulator, we'll be getting information about risk assessment on our website. We've already got a lot of information there that I've signposted you to. We won't be giving individual risk scores, and you will be aware of your risk rating, firstly by the contact you have with the SRA. So the higher impact firms, which are likely to be the bigger firms, will have, as I've mentioned, a relationship manager.
Helen, I have a question here. Won't this approach put a lot of firms out of business? Well, perhaps I can deal with that myself. No, we don't believe so. Our flexible approach means that firms should not be burdened with unnecessary regulatory demands which they struggle to meet. We will have a grown-up relationship with those firms which will work with us and give the best possible outcomes to clients. Only those who are unwilling or unable to work with us face tough sanctions. Also, the move away from prescription will help smaller firms to compete with ABSs.
Nikki, I'm just going to return to the risk theme
Right.
because a question has just come in asking what types of firms will be categorised as high risk. So I'll just repeat that they're likely to be the larger firms, perhaps because size of firm is a factor in assessing impact. It's going to be the larger firms that are designated high impact, high risk.
And by impact, Helen, we mean that sort of the effect, if something goes wrong, what effect it will have on clients. It doesn't mean that it's necessarily a more risky firm, or it doesn't mean that anything that it's more likely to have something going wrong. Is that right?
That's absolutely right, Nikki. It's the risk to our regulatory objectives, the SRA's regulatory objectives, and high risk. I've mentioned it a couple of times, but it's an important point. Does not mean poorly operating firm. So it's something that we really need to focus on.
All right, we've got a question in, what do sole practitioners think about these changes? Well, we're working with all sectors of the profession to make sure that OFR and ABSs are fully understood, and we're working with the sole practitioners group with whom we have a regular dialogue. We hope a cross-section of the profession, including sole practitioners, will tune into our webinars, and if they haven't already managed to attend the roadshows, particularly have a look at our roadshow webinar next week. Helen, I think you've got a
I have. Somebody is asking if my firm is compliant with the current code of conduct, will we be compliant with the new regime? A very pertinent question, and again the simple answer is yes. Please bear in mind that those examples of compliance that I talked about earlier, evidencing compliance. It's also have a look at the handbook for indicative behaviours, that's very useful. So we fully expect firms to have greater flexibility in compliance and in evidencing it. Although somebody has asked, if the SRA does not contact a firm, how do you demonstrate good compliance? Well, we would expect firms to be demonstrating good compliance in those ways that I've mentioned, and then if your firm is contacted by the SRA, you will have that information to hand. Nikki, do you have a question there?
Right. Well, someone has asked, will you be making judgments about whether firms are viable? Well, it is quite possible, if this has a bearing on risk, which it very clearly can do, can't it, Helen?
Absolutely, Nikki.
So we're already looking at the issue of financial stability of firms, and our current thinking is being incorporated into the work of the risk and supervision teams. And we want to work with the profession on agreeing financial indicators.
Absolutely. Another question here about culps and coffers. As a junior lawyer working for a sole practitioner, what should I do to ensure compliance? And I think that really touches on the culps and coffers point, and the fact that ultimately it is the firm that is responsible for compliance. So the culp and coffer would have to notify of various matters, but ultimate responsibility for compliance rests with the firm.
And also it engages the principals again, where everybody has their own part to play, whether they're a manager or an employee, in bringing about good outcomes for clients, whether you're an employee or indeed a manager. So that's right. And do we have another question here?
Yes, we have a question on supervision under OFR. Won't supervision under OFR come in inverse proportion to a firm's capacity to deal with it?
Are you happy to deal with that?
I am, Nikki, yes, and I'd say the answer is no. Firms will be able to show compliance with the handbook in ways which best suit their own business. And we're working with firms to look and to talk about what is expected of them, and we've talked about ways of showing compliance already this afternoon.
Right. Well, thank you, everyone. We're coming to the end of this webinar now. We hope you've found it helpful. We hope you've enjoyed it. I know that Helen and I have. And so it's goodbye from me, Nikki.
And goodbye from me, Helen.